All right, it is 10 o'clock. I will go ahead and call the meeting to order. The chair notes there's a quorum present, and we'll do the flag salute.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, under God, indivisible, with liberty and justice for all.
Okay, 2.0 is additions and revisions to the agenda. So commissioners, I sent you an email last night and asked that we add to the consent agenda, consider approval of commercial lease renewal agreement with Interstate Concrete and Asphalt. This is the batch plant lease that we discussed during the last meeting, and we just got it back on Monday. So I'd like to add that if there's no objections.
Any objections? I do have some questions about that. That's kind of what
It doesn't get used on a daily basis. So like last week when I drove by, there were pickups all around there. So they were doing something. So they're in and out, and they want to continue.
Sure.
So.
Uh-huh.
Yes.
Commissioner Shannon, I've been in contact with the manager of Interstate Concrete and Asphalt, and they do use it as they have to have something close enough when they're pouring, and they do want to continue using it. They have to, I believe, in some of their contracts, and and he is aware that the loader is their responsibility, and they are working on the repair for that. I thought I shared those emails. If I didn't, I apologize.
I think yeah.
Okay, let's move on to correspondence and public comment. Individuals wishing to address the court may do so at this time and at other times throughout the meeting. Speakers are asked to raise your hand to be recognized by the chair. Give your name and address and limit comments to 3 minutes. For those who are new here, I should also let you know that we are on Zoom currently, so there's folks who are signing in remotely. So for those folks who are signing in remotely, it's *6 if you've dialed in your phone, and then the unmute is in the lower left-hand corner. And as usual, I will remind folks that we are very informal, so feel free as we move through the agenda. If you have questions or want to contribute to the discussion, we welcome that. I do not see public comments at this point, so let's go on to correspondence. We just have one item which came in from Oregon State University from the extension, just talking about what the current fund balance is. As a reminder, we contribute every year to our extension program here. And so they're just sending us a letter basically noticing that as of the end of the fiscal year, June 30th, 2021, the fund balance was $120,000. So for those who are interested in reading the full letter, that's part of the court packet on the website. Let's move into 4.0, which is a public hearing to receive public comment on ordinance number 2021-06 to classify the Oregon Department of Transportation's Mayville Quarry as a Goal 5 protected resource and amend the zoning map, comprehensive map of aggregate sites and comprehensive aggregate list to designate the site and 1,500-foot impact area as significant resource combining zone. The public hearing this morning will be heard according to the legislative public hearing process. This is the time duly set and advertised for a public hearing in the matter of consideration of and to receive public comment on the draft Gilliam County Ordinance number 2021-06 to list as a Goal 5 protected resource the Oregon Department of Transportation, ODOT, Mayville Aggregate Site Number 650, located near the intersection of Highway 19 and Carter Hill Lane, southeast of the community of Mayville, identified as tax lot 501 of Assessor's Map 6S21, and to allow mining. The aggregate site is located on land zoned for exclusive farm use. Gilliam County Planning Commission is favorably recommending this action. The public hearing will be conducted as follows. Staff will give their report and answer any questions from members of the county court. Following the staff report, I will then open the hearing for public testimony, proponent, neutral, opponent, with the applicant having an opportunity for rebuttal. After the opportunity for public testimony, members of the county court may have additional questions for staff. Then the county court will decide whether to close the hearing and deliberate the matter. I will now ask members of the county court to disclose any conflicts of interest or other matters that may preclude your participation in these proceedings. Please indicate the nature of the conflict and state whether you intend to participate in these proceedings. Any conflicts, guys?
I don't believe so.
I don't either. Does anybody wish to challenge the ability of any member of the county court to participate in these proceedings? Let's see, anybody unmuting, anybody in the courtroom? Don't see that. Okay, moving on to testimony. When you testify, please state your name and address for the record. The hearing is being recorded. Please be courteous and avoid repetitive or redundant testimony. Please keep your testimony concise and relevant to the issues before us this morning. Testimony should address the applicable approval criteria listed in the staff report. All testimony shall be directed towards the county court and not to other members of the audience. To expedite the hearing, the members of the county court may ask questions of persons as they testify. The applicable criteria are listed in the staff report. These are the criteria the members of the county court will use to make its decision. If you believe there are additional applicable approval criteria, please identify such criteria when providing your testimony. Failure to raise an issue with sufficient specificity to afford the members of the county court and all parties an opportunity to respond to an issue may preclude an appeal to the Land Use Board of Appeals based on that issue and may preclude the ability to pursue an action for damages in circuit court. Staff will now present the staff report and any correspondence on this matter other than those items already included in the record. Good morning, ladies.
Good morning. Doesn't move very easily.
I know.
Yeah, there's no wheels on that one. That's one of the jury chairs.
Oh, good morning, County Court. My name is Michelle Colby. I'm the planning director for the county, as you all know. And we have hired Carla McLean to assist us with the ODOT Quarry. And she's provided detailed information in the staff report, and she did all the staff reporting to the Planning Commission. And so she'll deliver that to the county court today.
Good morning.
Good
Good
morning.
morning.
So thank you. As you went through the notice requirements, this is an application from the Oregon Department of Transportation, and that's a lot of work, so I'm just going to say ODOT. They have owned a particular piece of property there outside of Mayville for many, many years. It is currently covered by a conditional use permit. This action will replace that conditional use permit if and when you approve this. In about 2014, they expanded the site. It was previously around 5 acres. They've expanded it to the current 13.17 acres. And so this approval would apply to the full site. So all 13 plus acres would be under this approval. This is a goal 5 approval. So I know that goal 5 can be confusing to people who don't do land use on a daily basis. And I just want you to understand kind of the difference between what they have and what they're asking for, because I think that's an important thing to know. So what they have currently is a conditional use permit. It is a land use permit and is subject to review and evaluation. They did go through a process with that conditional use permit to list the site in your inventory, but not as a significant site, only as a site that is on farmland. So this really takes that conditional use permit and that significance as a local site to a different level. And what you're saying in this process is that this is significant. The rock that is here has value. It needs to be preserved for this use. Goal 5 is the natural resource goal, and it's the goal that we look at birds and bats and flora and fauna and all of those things, and then we look at aggregate. And aggregate is the one item in Goal 5 that we conserve to consume. Everything else in Goal 5, we preserve it because we like it, or because we should, or because some other entity said you shall. So Goal 5 is an interesting goal, and aggregate's role in that is unique. And so what this accomplishes is we protect the site under Goal 5, but we protect it and then we allow mining so that we are consuming that resource, and we're saying it's an important resource. And we know that when the resource is extracted, there will be reclamation that may not take it back to exclusive farm use as we typically think of exclusive farm use, because we think of farm use as being in this county dryland wheat or, you know, those other kind of agriculture applications. But if you were to look at this bluff currently, it's not farmed because it's a rock bluff, and that's what they're mining, is the rock that's in there. So it's kind of the difference. You're going from a conditional use permit with a locally significant to this is protected under Goal 5, and we're going to allow mining and all of what that means. So there are a couple of aspects to this that you're looking at from your comprehensive plan. At the conclusion of this, what you do is you have a map that says this is where the site is, and this is the site that is significant, and this is where this is what we're listing. So when you look at the Excel spreadsheet list, you'll see Mayville on there, and in the far column it says, yes, now it's a Goal 5 protected site. I think it's your second Goal 5 protected site. This one and Philippi Canyon, which was done about 3 or 4 years ago, 18, I think it was. So almost 4 years ago, 3.5. So you'll have 2 Goal 5 protected sites in Gilliam County, and you're thinking, we got a lot of aggregate sites, and you do. And most of them are on that list if they are currently active, and they are probably, if they're on farmland, they have a locally significant designation. That's why they're on the list. Then you have a map that also shows where all those sites are. And those are the 2 documents that you're going to look at. But then you're also going to apply through your zoning ordinance a significant resource overlay zone. And that particular overlay zone will be on the property, but it'll also be applied to the 1,500-foot impact area. And what that does, again, going back to Goal 5, you're protecting the site. And part of protecting it says we don't want things adjacent to it to conflict with it. So when we protect it, we want to protect it from encroaching or uses that might become a conflict with the mining activity. What you're doing is you're saying mining activity adjacent to it. How do we balance that, and what is more important, and how do we adequately protect the aggregate? And I think what's important to say here is that the Planning Commission really delved into that conversation, and we continued that hearing so that we could more fully evaluate the impacts to the adjoining property owners and to the portion of the community of Mayville that's actually included in that 1,500-foot impact area. Not all of Mayville is, but about half. Yeah, about half, roughly. And so what we did when we came back the second go around is we looked deeper into that. When you go through a Goal 5 process or a comprehensive planning process, you're required to, one, evaluate all the 14 statewide planning goals, but you're also required to do what's called an easy analysis. That's where you look at the economic, the environmental, the social, and the energy issues related to an activity, and you balance them. So we said things like, well, if we allow this, what are those consequences of allowing the mining? And how do you allow the mining and balance that against the other uses that are allowed in that impact area? And part of that impact area is zoned exclusive farm use. And Mr. Stinchfield is here again today. He did testify at the Planning Commission. He has property in that exclusive farm use area. And there is a previous condition from the conditional use permit related to a cistern on his property and a related there's a related well. The well was not addressed in the conditional use permit initially or originally, but the cistern was. And so we looked at that closely and said, we need to maintain those protections from the mining activity. But then we also looked at the community of Mayville, which has a rural unincorporated communities zoning, and it allows dwellings and some other activities. It's like, well, we don't want to say no to the dwellings. But your code is really clear. We have to apply the impact area. Luckily, when you wrote your code, you gave yourself two paths. You have a path that says, we're not going to allow anything in the impact area, or we're going to allow things to happen, and there are some provisions that are available to allow those activities to happen. It's additional review, and it's a burden on the person making application in the impact area to show that they're not going to impact the mining activity. You are protecting that mining activity from encroachment or claims of relief against that mining activity. And it's really interesting because your comprehensive plan and your code are very much written in a way that when those were adopted, there was clearly a determination that you valued aggregate. You placed a value on that, and you said, we will protect that resource and we will protect that activity. So the Planning Commission talked about that. And again, that's why we came back for a second go around to have that conversation, delved deeper into the code and said, yes, we need to imply the full 1,500 foot impact area, but then we can apply this kind of different version of allowing those potentially conflicting activities to happen. So in the end, you're not limiting any actions. You're not saying no to anybody doing what they could normally do in that impact area, either on farmland or in Mayville. But there is a provision that says they have to sign a waiver of remonstrance, which says we won't make a claim of relief against the mining operation. So there is the protection to the mine operator. And this would be available. This isn't just available to ODOT. These provisions and protections would be available to anybody who chose to go through the Goal 5 process with an aggregate site. So far, 2 sites have, and they're both owned by ODOT. But that doesn't mean that John Smith with an aggregate site couldn't go through the same procedure. Got it. So that's really kind of a real high level of everything to this point. And I'm happy to answer specific questions you have, but I also want to respect your time. So let me know what else you want to know. Do you want me to get into some of the devil in the detail here? Do you have questions? Are you comfortable with what I've shared to this point?
Commissioners, questions?
I think I'm comfortable with what you shared. Was there any concerns from residents of Mayville?
So again, Mr. Stitchfield did testify, and he made it very clear that I wasn't affording enough Goal 5 protections to his property. But there are no Goal 5 protections that have been applied to his property. So, you know, I think the Planning Commission certainly recognized that and wanted to make sure that we found that balance between protecting the mining operation and allowing, whether it be Mr. Stinchfield to do what he wants to do on what's allowed for him to do on his farm property, or for the residents of Mayville. There was another email that Michelle received, but she responded and tried to answer the question that was raised and had no further correspondence. I'm not aware of, and then of course ODOT is the applicant, and they do have a representative that has participated in the hearings process to date. So.
And I haven't received any further emails to date regarding the matter.
Yeah.
Just double check.
Additional questions?
I don't think I have any.
Okay. So are you comfortable with when I described how your zoning ordinance works and allows, you know, full protection or a modified, you're comfortable with that?
Yes.
Okay. Okay. Perfect. Yeah. All right. I think that concludes our staff report then.
Yeah.
Okay.
Okay.
Thank you.
Thank you.
You bet. Thank you. Let's go on. The hearing is now open. At this time, we will receive public testimony. Proponents of the application shall speak first. Opponents of the application shall speak second, and neutral testimony shall proceed third, and any agency comments next. The applicant is afforded the final opportunity to present testimony. So we'll start with and I think there's a sign-in sheet in the back. So folks who want, is it in the back,
Yes.
Teresa? Folks who are interested, if you want to testify first and sign, that's fine too. We just need to make sure that we've got everybody's contact information down before you leave. So we'll start with anyone wishing to speak in favor. of the application.
From here
If you could come on up so that our little owl can pick you up and our folks who are remote can hear as well.
All right, my name is Scott Billings. I'm a geologist for Oregon Department of Transportation, 63055 North Highway 97, Bend, Oregon 97703. And just really quick, at this point, we are in full agreement and support of the staff report that was just read. That also came out October 26th is the one I read. And so we basically agree with that and of the Planning Commission's recommendation to adopt the amendments that are in there. And then, yeah, that's it. Pretty simple at this point. This is our third meeting, so.
Commissioners, questions for?
All right.
Thank you.
And I'm open for more questions during the day here too. So. Thank you.
I want to just look online too for folks. Is there anybody who signed in through the Zoom that wishes to speak in favor of the application? *6 to unmute yourself. I'll just give you a second. I don't want you to miss your opportunity. I don't see anybody unmuting. So let's move on to, is there anyone who wishes to provide neutral testimony? Courtroom, anybody online? I'll give you a minute again. Anyone who wishes to present neutral testimony? Is that you, Mac?
That'd be me, I guess.
Come on up, see us.
Max Denchfield, Gilliam County resident, Mayville property owner, interested person. I live in Condon. I appreciate the Planning Commission's second go around on looking at the application, and it made me feel a little better. My family homesteaded that area out there in the 1870s, and they were nothing if they weren't community minded and community spirited. And in that vein, in the 50s, they sold a plot of land to the state on a hillside that they had used for grazing and has been used for grazing ever since. With the thought that they were going to help their community and move on and get good roads in the community and all that. And they have, and it's been a good relationship all these years. I've been dinging around out there for the last couple decades and really not given the planning goals and all that too much of a thought, which is odd because I helped develop Gilliam County's plan 40 some years ago. Some things just escape you. 40 years.
I can't believe you're just hold on to the nitty gritty details.
It's,
Planning
some
for.
things are hard to let go. But when I became aware again during these hearings, it struck me that, geez, the way this reads now, I won't be able to do anything. I'll have no recourse. My property is ground zero. It's borders the actual pit. So it concerned me, and I really wanted it discussed. It was almost like this is more important than that, and I didn't want to leave it like that.
Mm-hmm.
So I'm happy again that the Planning Commission gave it some sincere thought and consideration, and I'm happy with the way it is. I understand what's going to happen now if something does happen to my property out there due to some continued blasting or whatever. And I haven't been concerned about it yet, except for my reservoir, which has been replaced. And that reservoir, though, is served by the only well, or that well, city well, which also is in the 1,500-foot impact zone. So I still have some concerns that, not that I think they would, but just depends on people sometimes. I'd rather not see them go in there and blast and recklessly and willy-nilly, and just because now I likely will have no recourse if something does happen. I'd like everybody to think and be on the same page that that doesn't mean we can do whatever the hell we want. Just wanted to get that much information on record. And Mayville's a dear place, and not much going on right now, but who knows? And actually, that's kind of the way I like it.
You don't want too
Right.
much growth.
But I can't say that it's always going to stay that way, even in, and my family still has an interest out there. I would like it to be there for them.
So is the well that you're referring to, is that what the houses that are out there, is that their water source, the dwellings?
4 houses that are out there are served by that well. That well goes to my reservoir and back down to those 4 houses. 2 houses I know of for a fact are on their own wells. And that's about all the houses are ours.
Yeah,
So-
that covers it.
So if they did, I guess this is where I'm lost, if they did blast and damage something in that system, what happens there?
Well, we'll probably need some more technical explanation, but there are provisions for, as I understand it, not much to happen to ODOT in that case, but damages, I don't know.
Yeah, staff going to provide an answer to that. So the action before you today is the Goal 5 protections and the approval for mining. There's also a site development plan permit that is being issued. And that particular permit that will be issued concurrently with this, it's been out for comment. No comment has been received on it. But we incorporated, there is a provision in that particular permit that requires that ODOT provide notice prior to blasting. And there's a provision that allows the people that are noticed of that blasting to request that ODOT do both a pre and a post blasting review of any structures. So ODOT will provide notice if the person who's impacted requests it. Then there can be a pre-blasting review of the structure to determine what the condition, and then they would come back in post-blasting to determine if there was any harm or impact.
And that's driven by the landowner. So ODOT would do that at the request of the landowner.
Right. If
And
somebody
then-
doesn't want,
Yeah.
if somebody doesn't want an evaluation, they're noticing within 1,500 feet of the blasting. So that doesn't mean they would notice everybody within the impact area. It would be 1,500 feet of the blasting. So that's a pretty wide swath still, and it's still going to cover probably most as the mining continues to move further and further away from Mayville, it will shift. But that's the provision so we really took the planning commission condition from the conditional use permit, changed it a tiny bit and kept it in there so that ODOT still has to provide that notice. Yep.
Additional questions of Mac or follow-up questions to staff about that piece?
I don't think so. Thank you.
Okay, thanks for listening.
Thanks, Mac.
Thanks for
Appreciate
coming.
your work.
Can I ask a quick question?
Yes, Teddy, if you can state your name and address for the record. Are you speaking on neutral, maybe?
I guess. Okay, so my name is Teddy Fennern. I have interest in an address in Mayville. Do you want that address or my personal address?
Let's do your personal address.
Okay, it is 222 North Lincoln Street and P.O. Box 743 for Condon, Oregon, 97823. And just a quick question was, how are they notifying folks when they go to do that blasting out there? It just seemed that in the past it all of a sudden happened and we really didn't realize it. My mom lives right next to Mac's property. And so just my curiosity if they notify them like in the newspaper, or do they mail them something or give them a call, or?
Can you speak to that?
Yeah, so again, this is Scott Billings from ODOT. It used to be 48 hours notice, so it wasn't a mailing, it wasn't a newspaper thing, it was a phone call or go to the people's houses to notify them. It's now a week. I still think it's gonna be the old way, but because the mailing list isn't gonna be 50 people long, so anyway, I expect it to be still going around or calling, but if there's a different method that some people like for whatever reason they would like to be notified a different way, they could just let us know, and that could be, just let me know, or it could be part of the site development plan condition that already says the 1 week a notice, so.
Okay, so that does answer that, and thank you. So just out of curiosity, if somebody said that they wanted to have that inspection done pre and post to make sure that there was no structural damage, since my mom's house is literally just very close to that pit and it shakes the whole thing, how do we just ask, and will you have somebody available right away? It seems like a lot of times these things, take time to schedule with folks.
Right, so this is Scott again. Same thing. So the last one that was done was actually done by Gilliam County. So hopefully they reached out. I mean, I guess he would probably go around and talk to people personally since he knows them personally. But now with the week's notice, for sure, it's going to be very easy to do the structural inspection. So again, same process. Here's your notification that we're going to blast, and say on Friday, and then here's would you like to have your structure, your utility, your whatever inspected?
Thank you.
Go ahead.
Yeah, so I went ahead and pulled up the actual site development plan permit, and so I can read you the condition as it is specifically written. And again, this is a staff issued permit that will be issued concurrently with the decision you are making. For blasting notification, it currently reads, ODOT shall offer to property owners in writing the ability, it does say in writing, Scott, so
Okay.
we're gonna shoehorn you in there, and these conditions can still be changed. In writing, the ability to have conducted both a pre and post blast survey of structures within 1,000 feet of the blasting operation, notifying the Gilliam County Planning Director and affected property owners 1 week before blasting operations occur. So that's how it is currently written.
And so do I understand correct? So the condition is saying ODOT's doing the pre and post assessment. If there's damage, however, there's no recourse. Am I correct in that assumption? So basically they'll know whether their house or structure is damaged, but wouldn't be able to seek any sort of damages from ODOT.
That would be a civil action. So that would be in this room, but with the other body that's normally here.
Got it.
Yeah. I guess my experience has been ODOT is usually they are a partner. I mean, as a state agency, they are a partner. The relationship that we have oftentimes with ODOT is a different relationship than the relationship we might have with a private operator.
Mm-hmm.
And my experience has been ODOT has been a responsible adjoining landowner and a responsible partner. Certainly could be considerations for should that condition look differently or there be more to answer to that. I think the history has been that there has not been significant impact. And where there has been, again, ODOT has proven to be a responsible adjoining landowner. But I'll let Scott answer that if he has anything to add as well.
I guess I would slightly different than what Carla just said, or to add on to it. ODOT doesn't do their own blasting. So it's actually any civil penalties or whatever would be covered by the construction company's bond or insurance, whatever
Okay.
it be. So, which is why, I mean, we film stuff. They're supposed to monitor their blast, having the pre-post work or pre-post stuff, all that proof's out there so that, there isn't the, oh, I have a crack, but that's been there for 20 years. But there's also, hey, that's a new crack. And your instrumentation said it was too high and therefore you guys have to pay. So
Got it. Okay. The other question I had, and I don't know if this ever happens. Currently, it's under ODOT ownership. What's the history of that ever? Would that ever potentially be sold to a private? I mean, because ODOT is a public entity. That partnership, I think the expectation is maybe ingrained in the culture, but a private entity, maybe not so much, to your previous point. And so I was just curious, I assume, I don't know, should ODOT decide they need to unload aggregate sites to balance their budget or something, could that happen? And what would that look like?
It certainly could happen. The permit is one that could be transferred. It would take a public process to transfer that permit. It may not take a public hearing process, but there would be a notice process at a minimum. The permit does not anticipate the pit ever being sold. The permit anticipates that ODOT will mine it to its conclusion and reclaim it and keep a portion of it for a stockpile site and maybe then allow a portion of it to be put back into agricultural activity, which in that area would be grazing, those types of activities. That's what the permit envisions.
Okay.
So that would be a staff answer to that question. Yeah.
Any other, I think we're still on the neutral testimony. Anybody else either online or in the courtroom that wants to do neutral? I'm not seeing anybody unmute. So let's go ahead and move on to, is there anyone who wishes to speak in opposition to the application? Anybody in the courtroom? Anybody online? Again, it's *6 to unmute yourself for the lower left-hand corner of your Zoom screen. We do not see. Is there anybody representing an agency that wishes to speak? Anybody? See anybody? Okay. Does the applicant wish to present rebuttal testimony?
no.
Does the staff have anything to add in response to the testimony?
I think we've addressed the questions that have come up. So unless there's any lingering questions, I think we're good.
Any members of the court have any further questions of staff?
I do not.
Okay. So it's the county court's discretion whether to continue the hearing or leave the record open. Continue the hearing and leave the record open, or close the hearing and deliberate. Court, what would you like to do? Do you think additional oral testimony is necessary, in which we would continue the hearing to a date and time certain? Or are you ready to close the hearing and proceed to deliberations?
We're very close.
I believe we are. It's the third hearing, and I think that parties are.
Anybody who's interested, they would be here.
Okay. All right. So if there are no further questions, I will now close the public hearing. Is there any further discussion by members of the county court?
I don't have any.
Okay. There is in your briefing sample motion language of what we're looking at. This is an adoption of an ordinance. So as you remember, this is sort of a three-step process.
I move to approve the amendments to the Gilliam County Comprehensive Plan and Zoning Map as proposed under land use file number P 2021-01, T 2021-01, and Z 2021-01, based on the findings of fact and conclusions of law contained in the presented staff report.
I will second.
It's been moved and seconded that we approve the amendments to the Gilliam County Comprehensive Plan and Zoning Map as proposed under land use file number P 2021-01, T 2021-01, and Z 2021-01, based on the findings of fact and conclusions of law contained in the presented staff report. Is there further discussion?
No.
All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. And then we would need to proceed with the first reading of ordinance 2021-06 by title only.
Do we need to move to have the reading?
Yes.
I move to have the reading of ordinance number 2021-06 by title only.
A second.
It's been moved and seconded that we have the first reading of ordinance number 2021-06 by title only. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion carries. Okay, I gotta find the ordinance now. Hold on one second. I have this up. Is it in here? Hopefully. I have it in here. Ordinance number 2021-06 to classify the Oregon Department of Transportation's ODOT Mayville Quarry as a Goal 5 protected resource and amend the zoning map, comprehensive map of aggregate sites and comprehensive aggregate list to designate the site and 1,500-foot impact area as significant resource combining zone.
I move to accept the first reading of ordinance number 2021-06 by title only.
A second.
It's been moved and seconded that we accept the first reading of ordinance number 2021-06 by title only. Is there further discussion?
No.
All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, we are scheduled, as a reminder, we do not currently have a second meeting scheduled in November. And so the next regular meeting is scheduled for December 1st. So that would be when we would look at doing a second reading and adoption. Thank you for your time.
Yes, thank
This
you.
was very
Thank you all.
helpful. And I feel very knowledgeable now about Goal
Oh,
5.
my gosh, yeah.
Okay, let's go on to the consent agenda.
Do you have any further questions about the consent
No.
agenda? Well, I move we accept the consent agenda, approve the consent agenda. Ginger?
Agenda.
I second.
Ginger.
It's been moved and seconded that we approve the consent agenda, which consists of consider approval of October 20th, 2021 regular meeting minutes. Consider request for consent regarding industrial ground lease agreement relating to proposed transaction, and consider approval of commercial lease renewal agreement with Interstate Concrete and Asphalt. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, let's go into unfinished business, discussion regarding Gilliam County Public Health, everybody's favorite topic. All right, so I like to give a preview or a recap of where we are. So for folks who are tuning in late to this discussion, this has been an ongoing discussion since March. Holly Winslow and Dave Anderson came to us back then, requested that we fund a feasibility study looking at the prospect of bringing the public health back to Gilliam County from North Central Public Health. We, at this point, have had 3 meetings on September 29th, October 6th, and October 20th, where we have started to delve into what the feasibility of this and what the structure potentially could look like if the court chose to move in this direction. During our last meeting, we had representatives from Oregon Health Authority on. And originally we had been looking at whether a 190 organization structure was going to work for potential partnership. OHA had asked for our legal counsel to consult with their counsel at DOJ. That discussion did take place. Carrie Connolly represented us and had a discussion with their counsel last week. And so I wanted to sort of share what the conclusion they came to and some subsequent conversations I've had with OHA, kind of tell you what I think our options potentially are and get some direction from the commissioners on where you would like to go. So on the question of the 190, Carrie and I believe the counsel at DOJ's name is Shannon, did have a conversation about the 190. Carrie's relay of that to me, which was an oral relay, not in writing, which is why I didn't forward you anything from her, was that there is nothing in statute that they found that would prohibit us from using a 190 should we decide to do that. However, OHA's sort of position on it is that this would be, aside from North Central Public Health, they have never done a 190. And so there are not really templates for this kind of partnership. And I don't think they would call this a mischaracterization to say that they are nervous about making sure that that entity would be formed correctly and all of the provisions put in place that are required by law. They are nervous about us looking at a 190. So it's technically doable, but they have concerns about us kind of needing to fumble through the process and that there might be some missteps in that direction. So one of the things that OHA encouraged us to look at is a model that Grant County and Union County both are currently using. And basically what it is the public health administrator is a county employee, but that county employee is at a 0.1 FTE, which is where OHA said that was sort of they were okay with that level of an FTE. So in the Grant County example,
0.1, 10%, is that?
Yeah. So in the Grant County example, Grant County has hired Kimberly Lindsay, the Director of Community Counseling Solutions, at a 0.1 FTE. And I think a $500 a month salary, basically. And then the county is subcontracting with Community Counseling Solutions to provide the actual public health services. So one of the things we've been discussing, should the court decide that it wanted to go forward with partnering with the South Gilliam Health District, would be, could we do something like putting Holly on the payroll at a 0.1 FTE? That would hold, Holly would then be accountable to the court for all the reporting, ensuring compliance, any reviews. She would have to work directly with OHA when they come in to review, are we in compliance with all of the statutes for each of the program areas? And then the county would subcontract with the health district for those services, the actual vaccinations, all of the things that we determine are things that we actually want to be part of public health. I did ask the question because we had talked about environmental health and that was likely not something that the health district here was going to take on. And so their recommendation to us was that if we're subcontracting that's a county subcontract. So if we decided that, so it wouldn't be the health district going out and finding the subcontractor, it would be us, or rather if we hired Holly as the 0.1, Holly going and working with, whether that's Umatilla or North Central Public Health or Grant County, whoever it is that ultimately we determine is the best fit for environmental health, we would then be signing a subcontract as the county to that other entity. And I asked if there was any concerns or problems with that, and they said, no, not at all. They didn't have any objections to that. They just wanted to remind us that the enforcement action still is our responsibility. So if we contracted, say, with North Central, while they would do the inspections, it would be under the county if there's any, you know, findings or problems, basically, any
Who
enforcement.
would issue the licensing under that?
I believe it would be the county. So it would be, you know, the inspections you'd sort of have your subject matter expert doing that, but it would be all coming out under the county's sort of logo. So they're acting on behalf of Gilliam County, basically, as a subcontractor. And they also said that on environmental health, which I didn't think of this, and I don't know if there's anybody just floating out in the universe, but they also said it doesn't necessarily have to be an agency. It can be an individual. So if there happened to be a former inspector that needed part-time work here, they could be subcontracted for that as well.
There must be some certification.
Yeah.
Or they would have to approve some.
I
sort of
assume,
certification, I would think.
I assume so. And I highly doubt we have, I mean, a retired somebody just
Right.
eager to get back
Floating
into
around.
inspections, but you never know.
Once John from Possibly County wants to do it.
Yeah.
I ran into him the other day.
So that was the only part of the programs that we may need to subcontract in addition to the planning. I'm trying to think of, I didn't bring my notes. I can't believe that. I have a briefcase full of stuff and not that.
Yeah, so one of the things, and I think Holly can speak to this as well, and some of the other counties also subcontract out their WIC program.
Right.
So that is possible. I mean, any of these provisions can be subcontracted out. So if the South Gilliam said, you know what, we are actually really great at doing prevention and vaccines and we don't want WIC, I don't think Holly will tell you that that's their position, but hypothetically, if they did say that, the county is at liberty to subcontract wherever.
Whatever services in addition. that they would need.
Exactly. So basically how that looks is it's similar to somewhat similar to how our mental health with CCS works, is we sign the contract with the state saying, yes, we want it. Yes, we will provide these services. And then we formulate subcontracts with whoever we need to actually perform the service. So aside from the administration, which they made very clear multiple times, has got to remain within the county. That cannot be subcontracted. But that can be satisfied with a 0.1 FTE. So in terms of cost structure and benefits, with a 0.1, they're not benefited. We don't have to worry about union representation. I mean, most of the cost drivers then are contained at that level of an FTE. And so one of the things, before I presented this, I wanted to make sure that the health district wasn't going to say, whoa, this is not even something we're interested in. So I did run it by Holly. So one of the things we talked about is we could look at the sort of sample budget that they put together in the feasibility. And we could, for instance, say, okay, the financial stuff that we are anticipating sort of farming out to the district, we're going to keep that administration piece in-house. And so we would pay Holly directly here. And that just is less money that then would go to the health district for Holly's time. That made sense.
So when I think through this, and I'm trying to apply some common sense to my common sense, if that's what it is. But so we have 10% of the time we're paying for, but this is going to require a lot more than 10% time, and it is the county's responsibility, regardless, through OHA, to make sure that this is implemented properly, and we're the ones responsible if it's not.
Correct.
Right.
So Holly, again,
I'm
this
having
is,
some trouble with the math and what we're.
yes.
see what I'm
So
saying?
again,
Yeah, it doesn't seem quite.
this is the hypothetical, but if basically what OHA is saying or has said to us is that in the other two models that they have seen this, which is again, Grant and Union County, that they see as a bare minimum the 0.1% as an FTE. They feel like that meets the statutory requirement that that the administration be within the county. That being said, I think the expectation for the district itself is, in addition to what Holly is spending here, that if there is additional need on the district side, once the money goes through as a subcontract, Holly would also be responsible. In essence, she'd be responsible to us in two different ways: as an employee,
Right.
and also as the leader of a subcontractor. And so the time that she spends on the subcontractor part would be in addition to that, right? So her practitioners, the time that they spend, if she decided that she needed to hire an additional person within the district that she's overseeing that's helping with reporting or whatever for their compliance side. So I'm not suggesting, I guess what I want to say is I'm not suggesting that OHA is saying, oh, 4 hours a week is all you need to run
No, I don't think
public
that's-
health.
I don't think
That's not what they're
saying.
saying. My anticipation would be that Holly would have additional work on the district side, making sure that the district is in compliance with the subcontractor with us.
Then the fiscal responsibility also lies within the court.
Both, yes. So
But I
it's,
mean, when they're looking at whether we're in compliance or not, we're responsible for the fiscal side, not we're responsible to make sure that that part's done correct.
ultimately, yes, we are responsible for making sure that the funds are spent
We
appropriately.
answered OHA no matter what
Yes.
regard.
But to be clear, we are not cutting checks for everything that public health is doing. So we would pay the employee for their salary, and then the rest of the money is basically being passed through the subcontractor. And so our responsibility is not the AP piece of, reviewing all the invoices, and
Right.
it would be making sure that the subcontractors are using the money appropriately. So it would be, reviewing, okay, how is that money going through? The nice thing, one of the things that OHA talked to me about is when you're doing subcontractor work, one of the expectations and the hoops we'll need to jump through is doing risk assessments of the subcontractors. What is the risk that they potentially would be in non-compliant? One of the advantages of working with a public entity is that there are already built-in safeguards, right? There's already auditing, Holly's got a board that's reviewing budgets and making sure that they're following public budgeting law. And so some of the things that potentially a nonprofit who doesn't work in the public space might have to adjust their internal controls and things, a public entity should already have a lot of those expectations in terms of managing risk built in, because they're already a public entity.
But as a contractor, South Virginia Health District would not be reporting to their board for any part of the local health. They would be reporting to us
For public health.
for public health.
They would,
Their board would be overseeing public health for Gilliam County.
no. Their board, though, where their board comes in is that South Gilliam is going to have to run that money through their budget. So their budgeting process is still going to, their board is still going to have a say in how, or input and oversight responsibility, because that money is going to have to be tracked through South Gilliam's budget, right? Because Holly can't just take money in and not account for where it went. So in terms of whatever oversight responsibilities the health district currently has over how those monies are spent, whether they're reviewing checks every month, I don't know exactly sort of how their internal financial controls are set up, but they would continue to do that, and the public health dollars are going to flow through there as well. So ultimately, they're responsible to us because they have the subcontract with us. And so in essence, their board is going to be approving a contract with us, and their responsibility then lies in making sure that Holly and her team are in compliance with the subcontract that they're signing. So they're not they're not accountable to the state for public health. They are accountable to us as our subcontractor.
And the board is aware of how that all functions and they're on board and.
So I've had the conversations with North Central. Shelley set up a meeting with me, and Kathy called me yesterday. Kathy Schwartz called me yesterday.
Shelley's on, by the way, on Zoom too.
And one of the things that Kathy asked me is if we could make sure that, or that I would ask that we could make this a July 2023. Because they don't believe internally that all this stuff can really be put in place, because none of the programs are template programs, and they all have their own requirements and own training for each and every type of program. Now, this is feedback from them. The other thing, of course, is a concern is that they're in the middle of a pandemic, and to unravel everything that's going to be needed to be unraveled, 6 months is going to be a really, really hard time to do with the pressure they're on in other areas. So that's what they're communicated to me. And you know, I'm on the board. I understand some of the obstacles that the health district's going through right now with the current climate, and some of the things that have to do beyond what normal operations would be. So I'm throwing that for consideration.
But wasn't that something we discussed?
And one other thing that they did say in the interim that might be because obviously we feel like we got some real inadequacies with what's been going on, that maybe they could contract with South Gilliam in the interim for certain services that you feel like we're not getting through current public health. Contract those, they would contract those through Gilliam County so that we did get the services, providing we get them on both ends of the county.
Okay. Let's speak to timing first. That definitely came up with in my conversation with OHA yesterday as well. OHA wanted to make clear that they will do whatever the court determines it wants to do.
So will North Central.
Yeah.
So will North Central.
Yeah. So we had discussed, he and I, it was Andrew Epstein that I had the conversation with yesterday. We discussed, you know, a July 1, 2022, January 1, 2023, and July 1, 2023 as sort of three potential options. He did say from in terms of getting the paperwork up and running, that he thought that the July 1st, 2023 date makes it a little bit cleaner because it's a new biennium. And so typically their contracts are, because it's a state program, those are usually biennial contracts, 2-year contracts. And so not that we couldn't do for the last year of the biennium, but he was just making the point that, for instance, if we did January 1, 2023, we will sign the contracts and then literally 6 months later need to re-sign all of the contracts and subcontracts because the new biennium will start. And so we'll need to redo all of those contracts. So I think OHA was leaning toward the same thing that North Central Public Health requested or asked us to consider for different reasons.
And
But
reasons too, I think.
yeah. But he did say if the court decided that we want to do this upcoming year, 2022, they would do everything that they had to make it work.
One of the things about a July 22 is, say restaurant licensing is going to happen within the next 60 days, and those licenses are good throughout the next year. So when you start tearing this back apart, there's not a lot of restaurants in Gilliam County to deal with, granted, but I don't know what other licensing there is, there's public pools and everything.
Well, I think
those would there'd be some funds that the businesses had already paid in that would all have to be sorted out if you do a mid-year.
Well, I think there's a lot of the financials that are gonna take some time to pull apart.
Yeah, it's gonna be
Because
done
it's
right.
all been going in as a lump sum and then they're using it however, not separating it, saying Gilliam County had this much in the funds and this
And
is
then
the
they're receiving
services
it, gonna
they're
receive
getting
it.
back. That isn't happening. And so that's my concern too, is pulling those financials apart and saying, this is what we owe Gilliam County, that
It's gonna take a little.
what it's gonna take a while. Unfortunately.
One of the other things I'm just throwing that out there in terms of timing, just so that we're seeing the whole potential picture, especially on the financials, is that part of the funds potentially that are sitting in there that would expire prior to 2023 would be all of this COVID money that just came out. And so I'm not saying one way or the other, I'm just saying it's in terms of the financial picture. I know we had talked previously about if we go through the divorce, what the settlement's going to look like. That COVID money might be gone by the time the divorce took place, depending on what the timing was, if we decided to move forward. So the OHA had sort of shared, I think, most of, or a good portion of it, it's like staggered. It's not all rolling off on the same year. And so I think a portion rolls off in 2022 and a portion in 2023 and other programs maybe out in 2024. But that's not to say that North Central Public Health has to wait that long to expend the funds either. I mean, they may have already expended, depending on what their needs were, good chunks of that. So I don't know exactly what that financial picture was, but it is part of the financial picture is the COVID dollars that are sitting there that are Gilliam County dollars, really.
Yes.
Judge Farrar, can I speak?
Of course.
Please.
I apologize, I wasn't here for the last meeting, but I did watch the video a couple of times and listened to what the representative from the state had to say. I can appreciate these entities telling you what's best for them and how they would do things. But I would hope that the county court would think back about all the points that everyone has been bringing forth and what is best for Gilliam County. The timing, I don't think, just listening to you guys talk here and listening to the previous discussion, nobody's ever going to be happy. There's always going to be something that comes up. There was references made on the transition to two other different counties. One of them had over 50,000 people and one of them had over 20,000 people. I find it hard to believe that starting public health for 1,900 people is going to take longer than 6 or 7 months. If it is, it wouldn't be on our part. It would be on the state's part, getting through the red tape or whatever. But I didn't hear anybody say that it was impossible to do it. I heard the word ideal, not ideal. So, and then the other thing is, nobody even knows what program elements are being ran here in Gilliam County. Everyone we talked to said they don't work with North Central Public Health. We've asked North Central Public Health, what programs are you running here? That would give us an idea of what programs we're transitioning over. Well, so then my question would be to the state, can we prioritize? You're saying we can't get up and running? What's the most important program and would take the longest? I would say the WIC program. So that would be the program we would jump in and try to get that one going. For 2 years during the pandemic, it seems like everything else has been put aside anyway. So we're not seeing any of the programs. Mm-hmm. So is it all or nothing? Do all the programs that we intend to do have to be up and running by July 1st? Or can we start with the most important ones that the state can get completed with us? So I just really encourage you to really think of the bottom line of what's best for Gilliam County. Our clinic is really suffering right now because we're doing public health's job. we have to test now every day to accommodate our community and help people to be able to go to work, kids to be able to go to school. That's only happening because we have rearranged our staffing schedule to accommodate our community. So these problems aren't going to go away. And we feel confident that we can move forward and make this happen. And I have not heard one person say that North Central Public Health is doing a wonderful job here in our county. And I've not heard one person say that South Gilliam County Health District is totally incapable of handling this. So the other issues that are really seem like they're become talking points, and they're not going to be resolved until we jump in and get this done.
We talk money, but the bottom line is making sure that our residents have the services that they're entitled to. So,
Absolutely.
yeah,
And like I said, if we go this route with the $500 a month, the budget we propose would be reduced by the $6,000 plus the, Medicare and Social Security cost of it. And then if you're not implementing programs, then your costs go down. And she, the gal that talked at the last meeting, she kept referencing all this entanglement and property and, getting staff in place. And I'm not sure that she realizes how big we are. The report said we're using staff that we already have, and we would hire, now it would maybe be called something different. It would be maybe the manager of the whole public health department. That would be the only thing. And we have, in the feasibility report, we have outlined how we would do that in a timely manner. So I, again, think there were some like broad statements made and not real specific things that were said that maybe are kind of muddying the water a little bit.
Hey, Holly, we all talk about services,
Mm-hmm.
and I can only name 4, well, maybe 5. Let's take environmental services out because we know what that's about.
Mm-hmm.
WICs, reproductive care, immunizations, and tobacco prevention are probably the only 4 I've even heard mentioned in any of this at any time. And of those 4, it sounds like we've struggled in all those areas.
Struggled with
We're not getting the service you feel we're not getting the
Correct.
service in all 4. I haven't heard about any other services, and a lot of the talk is how all these services, and if we're only really worried about 4 initially or most important, and we're not even, these other services aren't even in the ballgame yet.
Right. Yeah, until you sit down with the state and can figure out what programs we would even be eligible for. So it's not like we're, reaching for the sky. We want it tailored to what our county needs. And right now it's not tailored to what our county needs. So I still, again, just find it hard to believe it would take 6 or 7 months. And the other thing is, I see it, right or wrong, I see it as 2 separate issues. One is getting a new health department up and running. The other is untangling, as they say, the county and North Central Public Health. I'm not sure where the state fits into that part of it. I would think the state's over here working with a new entity, and your legal counsel and you guys are trying to negotiate the divorce. Or whatever's going on there, but they've all, they've kind of brought them together and like they're all intertwined. And I can also, say, what if Gilliam County made the decision to pull out of North Central Public Health and turn it over to the state to run our public health? What would they do then? July 1st? Would they tell us, sorry, we don't have enough time, you guys, we can't run public health for you? I don't think they would.
No, I agree. We could talk forever about all the specifics, but we aren't going to know what it's going to entail until we actually dive in and start making it happen. So
Right. And I can tell you, I feel confident that we can make it happen. Any holdup would not be on our end, and it would not be lack of us trying. We have a history of taking on big projects and completing them and doing them well.
So here's what I think might be helpful is, and not to put everybody on the spot here, but I'd like to get a sense of where you guys think this is going. So, because I do feel like we are at the place, not necessarily like we have to pull the trigger today, but that I need direction. So if the direction is, yes, we think that we're headed towards pulling out, then I need to get OHA and our legal counsel kind of lined up on the, okay, what are the steps? How do we orderly do this? And also starting the conversation with Shelley and Commissioner Schwartz about what that exit sort of looks like. And maybe there's a hybrid sort of approach in the middle of this, because Holly was talking about maybe picking up, what's the, is there a staggered sort of, if we can get WIC up first, if that's the priority, and we get, so maybe there's sort of a conversation to be had with North Central if we should decide that we are going to move forward with the divorce, as we're calling it. Maybe it's a case of saying, okay, our goal is to get the entity set up, South Gilliam starting to do WIC and what they can take on. And then maybe we have a subcontract in place with North Central Public Health that they help us with some of these services while the district is getting, if we find as we get into it, is what I'm saying, that actually we do need a little bit more time to set up this piece of it. Maybe North Central is willing then to be a partner in some of that transition.
So if we shoot for a July 2022 date, why wouldn't it make sense for North Central? You've got services we feel we don't have. For the next 6 months, for them to contract you to do those services for them over the next 6 months to start it there. Start getting some of those in place under your umbrella.
We'd be willing to have that discussion, but in reality, if you make the decision, which I'm hoping that you will make, to pull out and start running in July 1st, we're gonna have a lot of work to do. And you've already paid North Central Public Health or paying them their share of funds
But they would have to pay
June 30th.
you.
Right, but it's not about the money. It's about the timing and the staff and the total inconvenience. We're adding physical therapy. We're now down one more office, two offices actually. I had to move out of my office, but we don't have an exam room, our blood draw room. So it's about space and giving the immunizations and things that, we're doing what we normally do, but to take on all that extra right now, like I said, we'd have the conversation, but I still feel that North Central Public Health has their duty to provide services through the end of the fiscal year.
I was just trying to answer the question that if they're not happening, if in the interim, that wouldn't be a good thing for transition. At least on one or two of them.
Yeah, no, like I said, we've been living through this for years. So our clinic has had to make adjustments, and just like we train staff to do the testing every day at a certain time to accommodate the needs of our community. So that stuff's already happening. I did, they asked if we would do the immunizations for COVID for the 5 through 11-year-olds. And initially I was, considering that option, but things have changed in our clinic. The fact that we're doing all the testing and the fact that we're down on space, we can't accommodate, we can't help them out right now. And so we expect them to come out and do those immunizations.
So take me back through the lack of space, because what's the answer to that by July 1st?
For,
Well, if you're short now, is that a temporary shortening?
it is a temporary short, and the majority of the staff is already, that would be working on public health, is already in the clinic, working. So the only new person would be whatever the manager, I don't want to say.
No, but it sounded like to bring public health in, you were concerned about the timelines of the fact that you're short of space now. Doesn't that become a bigger problem if you bring it in?
Well, okay, so I'll give you an instance. If I was running public health right now and we needed to do immunize the 5 through 11-year-olds, I would have a shot clinic. I would have a time either probably on a Saturday or a Sunday, or close the clinic in the afternoon to do those shots. But we can't intertwine the 5 to 11-year-olds with our providers trying to provide medical care all at one time. So and it's more convenient to just do like a pod or whatever, a chunk of time where you can do those immunizations. So that's something in our planning process, what we would do. And we would give different options to people, because we're already having people ask us about the booster. Well, we can't make it those 2 days that North Central is coming out to do the booster. So we're just saying, well, try to call them and see if you can go down to the Dalles and get the booster, or, you know, see if Murray's will get the booster. So yeah, we're just, I mean.
The potential concern I see too is if this is indeed a heavy lift in terms of getting it up in 6 months, then we're diverting our legal counsel and to do this subcontract for what is a relatively short time, instead of doing a longer term structuring. You know, I mean, just from a capacity standpoint, getting all the legal documents lined up to do that. If I have our counsel working on the subcontract with North Central Public Health, they aren't also drafting the bigger subcontracts that we need to be doing. So that, when I first threw that out there, I guess I was thinking more in terms of, as we get into it, if what we're finding is, you know what, we need a little bit more time to finalize the environmental health negotiation with, say we wanted to go to Umatilla County. There could still then just be an agreement in place that's a smaller one, sort of as we go, depending on how it rolls out, is what I'm sort of suggesting. That if there are pieces as we go, but I'm not sure. I feel like we're going to have sort of all hands on deck during the transition period. And so I see Holly's point of like, if we are saying, okay, you start taking on public health now, well, it's like, I think the anticipation is that they would be hiring another person. They would be, they need to build their capacity in order to be able to do that. And that's part of that 6-month transition.
But before we do anything, don't we have to stop talking and actually say,
yes,
we are going to do this?
Yes.
Before we can make any of this other stuff happen.
Absolutely.
We have to say, I move
Thank you.
to, and stop talking and.
Yeah. And honestly, I don't actually think we need a motion at this point, but we do need a consensus on where you want us to go, because I think what we would then do is the motions are actually come from our attorney drafting whatever document we need to submit to North Central, whatever contract we need to get in place with the state to take it. So we'll actually have legal documents that actually do this, but I do need some direction from the courts. Exactly.
And the contract with the administrator and all those things.
Exactly. I need some direction so we can get our legal beagles working on what we actually need the motions on.
Okay. Well, my consensus is we need to move forward. Everything that I've heard so far in the last 3 to 4 months is a positive enforcement that we need to bring public health back to Gilliam County for our citizens and our residents to make sure that they're getting what they're entitled to and what we can give them. So that's my position, is we need to make the ball roll so we can make the motions, so we can make it happen.
And do you have a preference on the timing of that?
Well, I think that's back to this team saying they think they can make it happen. And so I trust that.
Well, I really appreciate, Holly, what you said earlier. But I mean, I'm not here to argue with what you can do and not do. I understand that you want to make some changes, and it's really, you're the expert in this for within our county. So, I mean, I'm
Okay. And so, and I agree. I'm in that same place too. So am I correct? And what I'm hearing is that if we can make this work by July 1, 2022, that would be the preference of the court.
Yes.
And that Holly and I aim for that. And should we hit a stumbling block, that we will then come back to the court with your contingency plans if we need to move it to, say, January 1, to buy a little bit more time. Is that
Well, I think the sooner
inaccurate?
we start making these, I mean, we're talking about the things that need to be done, and the sooner we say we're going to do it, the sooner these things can start being worked on. North Central Public Health and Gilliam County have to start untangling, and to me, that's the financials, the biggest piece of that, and we need to get our attorneys working on these things, so we need to get started because it's already November.
Okay. Okay, so it sounds like we have a consensus that we are preparing to divorce from North Central Public Health. And am I correct? The direction of the court is that you would like me to move forward with working with legal counsel and Holly on starting to get those legal documents lined up and starting conversations with North Central Public Health about what a transition process out would look like.
Yes.
Okay.
Thank
All right.
you.
So what I will do is we will continue to just keep this on the agenda meeting after meeting. And we'll just provide updates when I have legal documents. We'll be bringing them. So we'll try to get attorneys starting on that right away. OHA does know that we were discussing it today, and I did tell Andrew that I would be circling back with him after this conversation. So he is ready to talk about next steps. Okay.
Thank you, ladies.
Holly, I'll be in touch.
I'll be there.
I might just put a desk right next to mine, and we can sit next to each other.
All right,
In my
thank you guys.
office.
All right. Yeah, you can share with Lisa. Okay, let's go on to new business, which is consider award a fall capital investment grant. So we had our fall 2021 capital investment grant cycle open and closed. We had only one applicant, which was the city of Condon. The grant review team met and reviewed the application in October. And their recommendations were part of the packet, but their recommendation in essence was to go ahead and fund it for the full amount. For those who are listening in and wondering what this application is for, it is for repairs for the swimming pool here in Condon. Just as a little point of reference, as you remember, we have a partnership with the city for the operational funds for that. So we have an IGA in place where we provide funding each year, and the city takes on the administration. So this is obviously outside of that. We don't have an agreement for the actual maintenance of the pool, which is why the city is coming asking if we are willing to fund it. Any thoughts, questions? I see Catherine's on there. Catherine, do you have anything to add?
No, the only thing I request, I guess, and this should make it much easier on you guys, is that if we can have it on a reimbursement basis after the first year, for the fact that I don't know if it's going to be exactly that amount, and instead of getting the 65% and having to get up to it, it would be easier if we could just get reimbursed for it. when we make the expenditure.
We can,
I do not see why not.
Yeah,
yep, and
that makes
we
sense.
often with our capital investments, we do it on the reimbursement and we just write that into the grant agreement so that it's clear.
That makes sense.
So do we have a motion on the
I
application?
move to award the fiscal year 2021-2022 capital investment grant to the city of Condon in the amount of up to $31,200 and to authorize the county judge to prepare and execute a grant agreement reflecting the terms and conditions discussed.
I will second.
It's been moved and seconded that we award a fiscal year 2021-2022 capital investment grant to the city of Condon in the amount of up to $31,200 and to authorize the county judge to prepare and execute a grant agreement reflecting the terms and conditions discussed. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, let's move on to 7.2, which is consider reduction and forgiveness of Cottonwood Dunn's addition project planning invoice. Lisa, do you want to
Sure.
do the overview on this one?
There was a thorough item briefing in your packet, but just to give you a quick recap. So the Johnsons initiated a conversation with our planning director some time ago. I'm going to say it was very early 2020, around a build on their property in the Cottonwood/Dunn's Addition area. In looking into that, we found some zoning issues. And then when you started to look at the broader, particularly the sort of industrial area, there was all sorts of uses that created historic grandfathered in zoning issues. And so it seemed like a good time to do that cleanup. We contracted with Tennyson Engineering to get that project done. And Dan Meader, who was still working for them at the time, he's retired now, baked into the cost of that project the fact that the Johnsons had initiated this, desire to build activity, and it was agreed with the Johnsons there would be a cost up to $3,000 that they would incur for some of this work. It was intended to be a 3 to 4 month project, but it got stretched out through no particular fault of the Johnsons, so that it was over a year before we actually completed that work and they were able then to be in a position to proceed with their build. Well, as we all know, over the last year with the pandemic and supply issues and what have you, the prices of construction materials went through the roof, leaving the Johnsons in a position where they were no longer able to consider their build. But yet they were still left with the $3,000 cost for initiating that discussion and their desire to build. But because of our hurry up and go slow on the project to address some more systemic issues, we didn't complete it in a time where they could actually leverage the benefit of that project. So Kathy Johnson came to me a couple of weeks ago and asked if the county court would consider either a reduction of that $3,000 invoice or forgiveness of it.
Yeah,
There was also her parting comment was, she's not the only one to benefit from this, yet she's the only one now who has an invoice for it. So it seems a little imbalanced on the teeter-totter perspective.
Disagree with that.
So I
Yeah.
just want to throw that one out there for you two to consider as you think about a reduction and or forgiveness.
Yeah, and just so you guys are all aware, we've already paid Tennyson, so this is really reimbursing the county
It is.
back for costs that we've already incurred. So, we're within budget. We don't need the money to come back to be within budget. So commissioners' thoughts on the request?
I think so too.
I kind of might have a conflict of interest because we're kind of sort of cousin related.
I'm not sure that counts in this community. I'm
No, because he was my first boyfriend, so no. Can't go there.
So we have two potentials.
I'm related to Johnson's remotely too, so we're all conflicted out, which means we can all vote.
I'm pretty sure somewhere in the
Yes.
Wilkins clan, there's some kind of relationship.
I'm
to
not
it.
sure what that says about the county, but anyway.
I know what it says. So I would move to forgive the $3,000 invoice to the Johnsons for the Cottonwood and Dunn's Addition rezoning project.
I'll second.
It's been moved and seconded that we forgive the $3,000 invoice to the Johnsons for the Cottonwood and Dunn's Addition rezoning project. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion carries. Okay, let's go on to announcements and next meeting. So as I referenced earlier, we are not scheduled for our second November meeting due to AOC's annual conference. So the next regular meeting will be December 1st. And then in addition, just as a reminder to folks, we are doing a housing work session this afternoon at 2 o'clock. So if you're listening in and want to participate, there is a Zoom link for that as well. People want to listen in from their office. We will have PCDC, the City of Condon, and other partners just talking about sort of where they are and maybe looking at if there are additional partnerships or restructuring that we need to look at to be more effective in our goal of producing more homes. Sherry, what do you have?
Can
Oh,
I
go
have
ahead.
a clarification on the work session?
Sure.
Is it completely Zoom or are we going to invite people in to the courtroom?
I think the courtroom will be open, so people can sit if they would like to listen.
Because of it being AOC and Thanksgiving and all those things, I do not have a Norcor meeting or a Capco meeting this month.
You get the month off?
Well, not totally, but
I mean, focused on
I'll be
this
focused on
stuff.
other things.
Not doing,
Yeah, but
not doing all of those
Won't have those two
meetings.
meetings, and I may participate in some AOC conference remotely, but I don't intend to attend this year.
You've been doing a lot of Shetler stuff though.
Been doing some Shetler stuff, yes.
Pat, what do you have going on?
I am going to attend.
Good luck.
And,
Have fun.
my
Come back
meetings are
with
not
COVID.
canceled.
Don't come back with COVID.
Come
Pat.
back with COVID.
So, yeah, we'll have North Central's meeting next Tuesday, Korea Friday.
Oh, I have Korean on mine.
The North Gilliam County Public Health has been meeting repetitively. I did sit down with the mayor and talked about a lot of things with him the other day of Arlington. And then the ambulance crew made a request to the city of Arlington to tuck the ambulance in under the city, which the city agreed that they'd be willing to look at that. The health district wants to keep it under them. We're going through some work sessions. Had one last night on hiring to fill the 2 open positions. Sounds like there's some concerns over the doctor who
Their medical director.
medical director wanting to see a plan in place for him. So they're trying to get a plan in place to keep that in place. Don't know that a lot got accomplished in their work session yesterday. I'm going to talk to the chairman of the board today and see where they're headed with that. But we do have ambulance service currently. It looks like they're willing to continue until we're through the process. And other than that, there's been a lot of North End health topic discussions going on for a while.
And I think it's just worth saying, if any of those volunteers are listening, how much we appreciate
Yes.
and understand that this is a painful period, I think, for everybody involved. And so we appreciate people putting the community's health and well-being above that, what can be a painful and difficult period.
Yes.
When you had your discussion with Mayor Buffton, did the water stuff come up?
Yes.
Okay.
And he's elk hunting or leaving the elk hunt, and I was gonna try to set a meeting up with him and May and Andy next week, so I'll have to wait till probably be actually in reality December.
Yeah.
I haven't reached out to Andy, but by the time we get through the convention and holidays and get into December, I'll put something together so the 3 of us can sit down. So, yeah, we had that discussion, a little bit about housing on it too, but I mean, primarily, he needs to be involved, the city owner needs to be involved in that right now.
Oh, absolutely. Yeah. Anything else? I don't have, I mean, we've got lots of little AOC meetings here and there, but otherwise it's pretty quiet at the moment in terms of meetings for me too.
Okay, well then you could get right into public health.
Yeah, yeah, to be clear, I'm pretty sure I will have plenty on my plate for November.
Right?
And December and January, February, March, April, May, and June. So if there's nothing else for the good of the order, it is 11:40 and I'll go ahead and adjourn the meeting.
Okay.